Howdy, I'm back. Video 3. Hopefully this won't be as big a problem for me as the first two videos for Chapter 5, because I'm still loving Chapter 5. We're gonna summarize this, our last point on the Economic Espionage Act and the laws to protect international intellectual property internationally. Now, there's a lot in this chapter. And what you want to learn about the Economic Espionage Act is this law was put in place specifically thinking about cybersecurity and stealing ideas, intellectual property through hacking. And so what you want to remember about that is this. Our biggest threats today are against our critical infrastructure, which includes, but also a big threat is on our intellectual property. If I can steal your design for a new product, if I can take advantage of your research, if I could do any of this, and maybe it's going to take me a couple of years to get what I need, but I'm not going to spend hundreds of millions of dollars, and then I can go out and I'm going to have an economic advantage of being able to produce something cheaper from you because I don't have to cover my R&D cost, which a lot of R&D costs are failed efforts in R&D, not just what leads to the successful product. We've seen this with Energizer Bear against ExxonMobil and BP, where scientific studies on where to drill for oil in the Middle East were stolen by Russia, right? We see it in China, where a cheaper product will come out according to those specs, pirated specs, and try winning in a Chinese or Russian court. So the Economic Espionage Act was motivated by the cybersecurity. How does that enable stealing IP? And it's based on something called the Uniform Trade Secrets Act. Now this is deceptive because you would think Uniform Trade Secrets Act, oh, that's a law, right? No. So let's talk about where this comes from, first of all, as soon as I find it. Okay? Brought up Wikipedia because, you know, that's our ultimate source, right? And it's a act that is put out for the states to use, so you're going to have some kind of consistency in trade secrets, but it's not exactly really an act. It's a model act. Hey, if you're going to do it, this is what you should do. And the UTSA has been, as it says here, enacted by 47 states, the District of Columbia, Puerto Rico, and the U.S. Virgin Islands. However, not many states actually implemented it as said. Okay, so let me give you an idea of how this is done, because this is important that you know when something is out there, if it's really law or not. So here's the original document drafted by the National Conference of Commissions on Uniform State Laws, and it's 17 pages, and it was done at the annual conference, and so it's approved by the American Bar Association, because, you know, God knows we want to do that, and who did it. And then this says, look, if you were going to put in a Trade Secrets Act, this is what it would look like. Okay, these are the definitions and the like. And one of the things you'll notice that the book says is that the Economic Espionage Act uses the definitions from the UTSA of trade secret. Okay, so how did that work with the states? Well, there is another document, which I believe is something like, I don't know, a couple hundred pages, that is nothing but a summary of Trade Secrets Acts defined by state law and federal law and how they compare with the UTSA. So this is, like I said, this is a long document. Let's see if we can find Texas on this. So here's with the Texas law, Texas Civil Practices and Remedies Code. And here it is, and here is what the UTSA said in the 1985 version, but here's how Texas implemented it. So when you say the UTSA, it is a model law. This is what we aspire to. This is what we do, right? We're 51 different jurisdictions in the United States. We are 50 state laws and we are the federal law. So gee, wouldn't it be nice if all of us had the same law? But in fact, we don't. I believe this document's 210 pages, and it is nothing but a comparison of how UTSA was actually implemented not only in the economic espionage law, let me get you all the way back to the top here, but also by state. So when we go back to when it says it was adopted as of May 2013, it had been enacted by 47 states, do you see the problem? You know, I'm a company in Indiana that makes something, and I'm going to sue, but I'm going to sue under my law. I'm a company in Texas, but I'm going to sue. And so while we have this law, that's a model law, not even the original, you can read this, not even the original Economic Espionage Act actually put into effect the UTSA. If you look here, if you can see this, does not include reverse engineering, independent derivation, or any other lawful means of acquisition, right? So just keep that in mind. And then what type of intellectual properties do we have? Patent, trademarks, trade secret, copyright, trademark. Well, a patent and trademark is by the USPTO, United States Patent and Trademark Office, hello. Copyright by Library of Congress. Trade secret is only protected by civil or criminal activities because we don't register trade secrets. Patents, copyrights, trademarks, we have to register if we want to get statutory damages or truly protect our IP, and we register them, but trade secrets we don't. In fact, we don't want to register a trade secret because we got to keep it secret. That's the whole idea of a trade secret. If I have a trade secret, it can last forever. Nobody knows the formula for Coca-Cola. But if I put that trade secret out on the internet and you go out and make Coca-Cola, I can't bring action against you if I disclosed it. Now, if you steal the secret, that's another issue. But the important point being, patent and trademarks by one government agency, copyright by another that we've seen in the preceding video, DMCA, but trade secrets we don't register. And cybersecurity has given us a mechanism to steal IP. So here's what I want you to get out of this. If you wonder why this is an important law, take a few minutes and Google Nortel and hacking. You ever hear of Nortel? Nope. For about 10 years they were hacked, $1 billion company that went bankrupt, replaced by Chinese system components and the like. So before the Economic Espionage Act, we relied on state laws, which I just showed you, were kind of a hodgepodge. They were mostly civil actions, and now we've criminalized theft. But it still allows for private litigation. So there are statutory damages, there are criminal penalties, there are things we can do to make you suffer in prisons and jails, but remember, criminal is the government versus an entity. But there are also civil, which is an entity versus an entity, and that's going to put damages back in my pocket. So now, let me tell you, there's a whole field of law out there for calculating damages. So for instance, if I say, hey, you stole this and I would have made $1 billion, pay me $1 billion, that's not going to fly, right? Your defense is going to be, yeah, we didn't steal it, but okay, if you want to say we stole it, you would have made $100. Here's $100, now go away. So there's this whole field of how you calculate actual damages and compensatory, which includes lost royalties and the like. But that's very complicated. So again, you're talking about long-term civil litigation. So if you, of course, you're reading your book, so, I don't have to point this out to you, but look at some of the interesting things that you, as a prospective employee or employer, will need to think about this on page 232. It talks about a person who took trade secrets and what happened to him. And once again, guess what? If I'm going to prosecute you or go after you in civil court for trade secret theft, I'm going to have to do certain things to protect me. I'm going to ask you to sign a confidentiality agreement. I am going to have to put in strong electronic security measures. I am going to have to put in non-disclosure agreements. I am going to have to mark documents as confidential. I am going to have to do things that I can go to a judge and say, Judge, I did everything I could for John Doe not to steal my secrets, and look, he stole my secrets. I did not disclose it. Okay? And if you look at this list, the judge noted a few areas in which they could have done better. The employer could have done better. look, as an aside, I started a company here when I was doing my PhD. It's still in business in College Station. At one time, I had 90 employees. If you're an employer or if you're an entrepreneur and all this, you're working, as we used to joke, half days. Which 12-hour shift do you want? Which was kind of a joke because many times I'd go to my office in the morning and not even leave until the next afternoon, right? And no matter what you do, you never feel like it's enough. But you do put in certain processes. So it's where it says explain the confidentiality agreements to employees, implement, refer them to a confidentiality agreement during their exit interview, ding, 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 ding. I would hand them a piece of paper and say, you initial it. And oh, I don't want to sign this. And I said, no, you are initialing it or signing it that you received this. Not that you're going to abide by it because guess what? This is Texas law. You've worked for me for 10 or 12 years. You've been exposed to this. All I am doing is reminding you what you signed when you were employed and that I own that intellectual property. And by the way, I will come after you if you attempt to steal it. So look at what is required by the employer. Now, you all are going to have a job after this, unless you win the lotto, right? And you're either going to go in, you're going to be an employee, and some of you will be employees, and eventually you will be entrepreneurs and business people and employers, and you're going to sit on both sides of the desk. So, as someone who worked in Austin High Tech for a number of years, as someone who had my own business a couple of times, let me tell you, neither side of the desk is comfortable, okay? As an employer, you don't like to be a jerk. Usually, sometimes you do. As an employee, same thing. You don't like to be a jerk, but I've been an employee before and I've been a jerk. But you want to be knowledgeable, both in your chosen career if it involves computers and as an employee of what you're signing in a confidentiality agreement, of things that you put in place, of things that you respect, okay? So basically, that's a long-winded explanation for this. And again, this is a relatively new law, which means 2016, guess what? Even though there's been a couple of cases, there's not been a lot of case law on this. So this is going to be something we want to watch and see what the courts say. And the courts could come back and say, no, this is too onerous, or hey, well, we'll figure this out, but it's going to take us 5 to 7 years. So you have all these definitions, but look at the date. This law is 2 years old. It's a baby. Now, I do want to point out one other fact on page 240, civil seizures. When you see equitable relief, other equitable relief would be inadequate. There's two kinds of damages. One is equitable, make it fair. That's what an injunction is. It's an equitable damage, okay? So non-equitable is usually your financial. So when we talk about this, they can do civil seizures. They can say, you did this, we've proven it. It's gone through the courts. But again, we're talking about a length of time for the courts to actually apply this law, define which cases are legitimate and which are not, work through the appeal section, which civil seizure, injunction, or damages could be considered too onerous or something. So this is something you're going to want to be watching for the next 10 years of your life. Also on 242, I want to point out one other fact. I believe in our first lecture we did talk about statute of limitations, but not much. Notice what this says. Plaintiffs must bring Economic Espionage Act civil actions within 3 years of the date the misappropriation was discovered or should have been discovered through exercise of reasonable diligence. This requirement is identical to statute of limitations in the UTSA. Think about this. You have to do your due diligence. What that means is, hey, on May 23rd, 2017, I discovered that this employee had done this and this and this, but it was 4 years before that. Could you have discovered it earlier? Should you have discovered it earlier? The statute of limitations can start when you should have discovered the malfeasance. And this, of course, is a gray area. So it's not when you said, hey, I woke up, read the Wall Street Journal, my former employer's just got VC money, he's taken my design. Well, when did he quit working for you? Well, 6 or 7 years ago. Well, when did this start? Well, when did you do this? You've got the burden of proof. So That's part of doing due diligence, but that is an important aspect. It's not just when the misappropriation was discovered, but when it should have been discovered. All right, that ends chapter 5. Upward and onward. Thank you, and we'll move on.